Madam President, I ask consent that the remarks I'm about to make be placed in a separate part in the record.
Without objection.
Thank you, Madam President. Behind the scenes of our nation's courtrooms and jail, you'll find some of our most dedicated public servants. They are America's public defense lawyers. They work long hours for low pay and even less attention and acclaim to protect the most American ideal, equal justice under the law. It's thanks to their service that every single citizen of this country is guaranteed the right to legal counsel. Well, this Saturday we have a chance to honor them. It's National Public Defender Day. And this year, National Public Defender Day also marks a major milestone in legal history. It's the 60th anniversary of the Supreme Court's decision in the landmark case Gideon versus Wainwright. Hard as it is to imagine, there were days before the Gideon decision when the constitutional right to legal counsel was not protected. That means in some states, if you were charged with a crime but couldn't afford a lawyer, you were on your own. That's exactly what happened to a man named Clarence Gideon in the summer of 1961. At the time, he was down on his luck, struggling with the disease of addiction on the streets of Panama City, Florida. Early one morning in June, he was arrested for a burglary. The evidence against him? A witness claimed that they saw him steal from a local pool hall. The police arrested him based on that accusation alone. When Mr. Gideon appeared in court, he told the judge he couldn't afford a lawyer and asked for an appointed attorney. The judge denied the request. He told Mr. Gideon that the court could only appoint a counsel to defendants facing the death penalty. In other words, Mr. Gideon was denied his Sixth Amendment right to counsel, which has been enshrined in our Constitution since the enactment of the Bill of Rights, because he wasn't accused of a very serious crime. Well, Mr. Gideon didn't need a law degree to know that something was wrong here. So he picked up a pen and a sheet of paper and wrote a letter to the United States Supreme Court. And with that letter, he changed history. The Supreme Court agreed to hear his case and finally appointed him an attorney, and not just an average attorney, future Supreme Court Justice Abe Fortas. Fast forward to March of 1963, the court issued its decision. All 9 justices ruled unanimously in favor of Mr. Gideon. In the majority opinion, Justice Hugo Black said, "Lawyers in criminal courts are necessities, not luxuries." And he concluded, and I quote, that the noble ideal of fair trials before impartial tribunals in which every defendant stands equal before the law cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist him. In the 6 decades since Gideon, generations of public defenders have stepped up to ensure that no one is denied their constitutional right to a legal counsel. And for our most vulnerable neighbors in particular, public defenders are an indispensable protection. They have protected the rights of low-income and indigent Americans. They've helped defendants access resources and services to get their lives back on track. And they've worked day in, day out to secure sentences that are humane and proportional. Moreover, public defenders provide a service to all of us by strengthening the integrity of our system of justice. Think about this. The United States has one of the highest rates of incarceration in the world. So when defendants are denied adequate legal representation, they can end up behind bars for crimes they did not commit or receive excessive, even inhumane sentences for those they did commit. That is a subversion of justice that wastes resources, violates fundamental values, and worst of all, treats humans as if they are disposable objects. So all of us owe a debt of gratitude to the public defenders fighting against these injustices. Madam President, I ask that the remainder of my remarks be placed in the record.
Without objection.
I yield the floor. I suggest the absence of a quorum.